Good work, members. Good work. We're ready to move on to the rules calendar a little bit further. Mr. Clerk, will you read a caption to Senate Bill 68?
Senate Bill 68 by Senator Kennedy, the 18th, and others being titled an act to amend Titles 9, 1340, and 51 of the Official Code of Georgia Annotated relating to civil practice, contracts, motor vehicles, and torts, respectively, so as to provide for substantive and comprehensive revisions of provisions regarding civil practice, evidentiary matters, damages, and liability in torts actions. This bill having referred to the Committee on Rules, that committee recommends that this bill do pass by committee substitute.
Representative James Burchett is recognized to speak to the bill. Representative Burchett, Whip Burchett.
Well, colleagues, this is for real this time. I rise to speak to you today about Senate Bill 68. And I just got encouragement from Chairman of Appropriations that if you'll just vote like we did on House Bill 68, we'll be fine today. So I know everybody has eagerly anticipated this bill coming to the floor, and I'm going to run through what the bill does. But for a minute, I want to just say this to you all. I know that each and every one of you is under a great deal of pressure from folks in the hall and folks back home, but I want to put this in perspective for you. Yesterday, this wasn't the law. Tomorrow, hopefully, it is the law. And guess what's going to happen tomorrow? Sun's going to come up. You're going to say, good morning to your kids and your wife, and life's going to go on regardless of what happens here today. So I don't want you guys to take this bill as life or death here. I know you guys are getting a significant amount of pressure, and I respect each and every one of your positions. Senate Bill 68 had roughly 15 hours of testimony, and I want to thank each and every member of the subcommittee and the chairman for thoroughly vetting this bill. All in all, 25 changes were made in the House to the bill, and I'm going to speak to exactly what the bill does. I know there's been a lot of talk about what the bill does, but I'm just going to put it in simple terms for you. I first think these are reasonable revisions to our Civil Practice Act, our evidentiary code, and then to our premises liability. The changes are as follows. In the Civil Practice Act, it determines how and when monetary values for non-economic damages can be argued. That's it. That's one section. Another section is when discovery can begin. That's it. That's what the section does. How long an attorney has to voluntarily dismiss, which we are doing. We're moving closer to the federal system. Currently, you can do it until the first witness is sworn in. We're moving to 60 days after an answer. The federal system is upon answer, voluntary dismissal. Next, we're clarifying that attorneys cannot double recover their fees. I don't think I have heard one person articulate an argument why attorneys should get double fees. And I realize I'm arguing against my own profession because I am an attorney, but I don't think it's patently fair for an attorney to recover twice for the same amount of work. Another thing the bill does is allows evidence for seatbelts. The best argument, I think, for this is that it's required by law for folks to wear seatbelts, and this allows evidence to come in whether or not the seatbelt was being worn. One of the most substantive changes and the changes to our tort provision is determining when negligent security shall lie. Now, there are two provisions within this bill that allow for two doorways or pathways to find whether or not there's liability. The first one is it's more difficult to find liability. But the second one, I would argue, is almost exactly what the totality of the circumstance is. And I expect that that is what is going to be utilized by attorneys going forward. And lastly, one of the provisions allows for the actual costs of medical bills to be submitted to the jury as evidence. And that's it. That's what the bill does. It's about how lawyers act in court, and then how and when a person can be sought for liability for negligent security. That's it. That's what the bill does. There's no hidden tricks, and I know that we're going to have a lot of testimony about the unfairness of the bill and how we treat victims differently. But I ask you, please, just read the words on the page. And I know it can be discombobulating to read these words because it is a very highly technical bill, and it is a lawyer bill. But I'll submit to you, folks, this is a bill that makes reasonable revisions to our Civil Practice Act and reasonable revisions to our evidentiary code, as well as reasonable revisions to our liability, third-party negligent security liability. And, Mr. Speaker, that's the bill, and I'll stand for questions.
The gentleman has a couple of questions. Let's see, I'll recognize Chairman Werkheiser to your left for a question. The gentleman's recognized.
Thank you, Mr. Speaker. Will the gentleman yield?
I do.
Is it not true that just by reducing the threat of excessive litigation, that this will encourage businesses to come here and to expand?
I know that is the intent of the bill. Yes, sir.
Representative Vance Smith to your right, Mr. Whip, is recognized for a question.
Thank you, Mr. Speaker. On line 170 and 171, this is in the seatbelt section of the bill, and it talks about if it's a failure, now I'm paraphrasing, a failure to wear your seatbelt, that an insurance company cannot cancel your insurance or go up on your insurance rate. So now we're going to tell the insurance in this one instance what they can charge and what they can't charge. Does that open the door that we can do that with other parts of insurance?
Well, I hope so, Mr. Representative. It is my intent to seek some sort of regulation upon the insurance company.
Can I follow up with?
Yes.
One additional question. So tell me, with that statement, I'm not a lawyer, with that statement right there being in this bill, and that will be the law. So if somebody finds out their insurance goes up, what happens?
If I'm not mistaken, that's already the current law too. So this is new language to this section, but it is already the current law. They cannot drop you or cannot increase your coverage because of failure to wear the seatbelt.
Okay, thank you.
Yeah, thank you.
Gentleman for the yield. Representative Darlene Taylor up the center aisle to your left.
Thank you, Mr. Speaker. Does the gentleman yield?
I do.
Is it not true that by passing Senate Bill 68, we're taking a significant step towards lowering operational costs for our small businesses here in Georgia?
I expect that to be true.
Gentleman, yield for one more.
One more.
Representative Judd Howard to your right is recognized for a question.
Thank you, Mr. Speaker. Will the gentleman yield?
I do.
Is it not true that allowing jurors to see both billed and paid, that this will promote transparency and fairness in awarding damages?
I think the gentleman knows what he speaks. I think this is a more fair system, allowing for the actual medical bill costs plus whatever is billed. So I agree with the gentleman.
Thank you.
Thank you, Mr. Speaker. I expect a good amount of testimony. I'm asking for your favorable consideration for Senate Bill 68. Thank you.
The gentleman has yielded the well. Here's our posture, members. We have those that want to speak that are opposed to the bill, to this measure. We have those that want to speak in favor. Then we'll have a minority report as well when that time is here. And then we have chairman's time. Here's what we're going to do. We're going to allocate 30 minutes for those opposed, and then 30 minutes for those in favor. And I'm going to allow them to allocate that time amongst themselves as they so see fit. So we'll begin with those opposed, and I'm going to recognize Representative Al Williams to speak to the bill. Representative Al Williams is recognized to speak to Senate Bill 68. Representative Williams.
Thank you, Mr. Speaker. This is not my happiest moment since I've been in the legislature. Here's a bill that could well have been worked out to the good of both sides. And for some clarifications for those of you who don't know, I've spent most of my working life on the small business side of the ledger. I started out in property and casualty insurance many years ago, and I still hold the distinction of having written the 2 biggest premium policies in the history of Southeast Georgia. I still stand there. I also wrote the biggest life policy ever written, so I've gotten quite a bit of money off insurance companies. But I've heard, and I also employed 200 people here for 3 years and transported 50,000 people a month to medical appointments. My liability insurance was pretty huge, 110 vehicles on the road every day. But there are a couple of things. A slightly overused term in Georgia is hardworking Georgians. I'm talking about hardworking, real hardworking Georgians today. It bothers me when a hard-working dump truck driver who's right-handed, living in North Georgia, loses his right arm. It bothers me when a hard-working Georgian in Southeast Georgia gets in an accident and is no longer able to work. It bothers me that these people could reach the point where the American dream disappears, not just for them, but for their children. All of a sudden, the child's education is not assured. Maybe they're not eligible for the Zell Mill scholarship, but they want to go to college. All of a sudden, they can't do it. Maybe because when they came out of the hospital under this bill, there are medical bills left that's going to devastate the finances of this family. Now, there are a few words that I have become mesmerized by in my years of development. One of them has been oxymoron. I love that word. And this bill is a perfect example of an oxymoron. Some of the arguments, folks. You can't tell me for 11 straight years you are the best place in this nation to do business, and then on the next hand tell me, what is the word, a cesspool or a hellhole for insurance? Folks, I have heard so many announcements over the last 6 years of businesses coming to Georgia. I've seen people living better than ever before. This hellhole has not taken 3-car garages away. This hellhole has not made the standard of living in Georgia enviable everywhere in the South. Don't tell me what businesses might do. All I know is they have not left. One of the very best friends I have in the world has been in business 55 years in Liberty County. He and I have had thousands of conversations, and he's never told me his business insurance is too high. He's mentioned the time when his roof got blown off and $12,000 bill, and insurance company settled for $7,000, and he had to eat the rest. Now that bothered him. I've spent all this time watching recruiting companies all over this country, and particularly here in Georgia, trying to bring business to Georgia. And the fact of our tort costs are number 10 in the list of 10. There are 9 reasons to come to Georgia. They're so far down the list. I've never lost a client to this in Georgia, and I've been on the Development Authority for 25 years. Hundreds of companies have come through, and not one of them has said, we're not coming to Georgia because your tort costs are too high. Another thing about hardworking Georgians, if we talk to them today, 90% of them would not know what in the world tort means or vodar. All they want to know is, am I going to get a jury that's going to be fair? And what do you mean by tort? You telling me I can't get, because I'm a hard-working Georgian, you don't think my claim is worth X number of dollars because I'm not a member of the country club. I'm just a hard-working Georgian. I'm just a farmer. So my recovery is limited. I submit to you, hard-working Georgians think the fairest court in this state is a court when you go in with a claim for damages. Because if you're broke and you commit a felony, it's not if you're going to jail, it's how long you're going to jail, because you can't afford a lawyer. But if you're broke and you have a terrible accident that devastates your family, you got a shot of being made surely whole. This has not bothered our progress in Georgia. I never heard a discussion about insurance premiums except homeowners and car insurance being too high until we made it the conversation. We sent people the information and they started calling people and people started talking. I serve on the board of a solar company. One of the dearest friends I have, who happens to be a white conservative Republican. Best man at my wedding in 1978. We differ politically, but guess what? He's never told me his insurance premiums were too high in all of my board meetings. Please don't fall for the rope-a-dope. It ain't about insurance premiums. Don't be there, folk. Look at it. The only insurance most people who are hard-working Georgians have is a homeowner's policy, a car policy, and a life or a health policy. That's it. This is not for hard-working Georgians. This is for good-living Georgians who want to live better. Let's deal with this for what it is. And I didn't want to come. My doctor told me not to even show up today. I'm not well. But this is too important, and I will not continue to see hard-working Georgians being used just on billboards and not in the boardroom. It's time for them to get a little play. Don't take away this shot. Don't let some girl who's been raped not be made whole. Don't let somebody who a motel operator did not secure his property, he can't be sued. You can't be against trafficking and want to take away the liability, responsibility of these folk. Folk, let's give it a thought and do something real for once for hard-working Georgians. Mr. Speaker, I yield the well.
The gentleman has yielded the well. Representative Roberts is recognized to speak to the bill. Representative Roberts.
Thank you, Mr. Speaker. Good morning, colleagues. I think it's still morning. I want to start by saying, frankly, to everyone in this room, to all Georgians, our families, our small businesses, healthcare providers, anyone whose insurance premiums have continued to rise over the last few years, I understand your pain. My car insurance went up again a couple months ago. My homeowner's insurance has gone up every year. I run a small business, a boutique law firm, and all of the insurance policies that are required to run it, those premiums continue to rise. It has taken a toll on all of us, and I share your frustration. The proponents of this bill have spent millions of dollars preying on our stress and frustration, telling us that this bill will reduce our rates, stabilize our rates, keep providers from leaving the state. It's simply not true. If it were, I'd be down here begging y'all to pass this bill. It would be against my own self-interest not to. So let me tell you why it won't stop our pain. First, there isn't a single line in this bill that requires insurance providers to reduce premiums, to stabilize them, or even keep offering policies. Second, I asked every advocate for this bill whether they could guarantee that it would do any of those things, and not a single one said yes. And third, I looked at the evidence in other states who have adopted similar legislation and whether rates came down or even stabilized. I bet you can guess the answer, not a one. In fact, Florida passed tort reform a couple of years ago, and their rates have gone up by 30%. And their Republican Speaker of the House has launched a fraud investigation into the information provided to their state legislature to prompt them to vote for similar tort reform that has increased, not decreased, their citizens' pain. So what is true? I didn't know some of this. Did you know that Georgia ranks 4th in the nation for the number of fatalities involving any vehicle? We rank 4th in the nation for the number of fatalities involving commercial motor vehicles. And we rank 1st in the nation for violations of drugs and driving under the influence for commercial drivers. Despite these statistics, Georgia's insurance rates and insurance market are competitive. The cost of defending claims in Georgia for insurance companies is actually less than the national average. The insurance industry's own data shows that the average amount of total earned premiums used to defend Georgia claims brought by attorneys is only 3.3%, less than the national average of 3.7%. Georgia's defense costs are similarly less than the national average for commercial automobile liability and commercial general liability. And Georgia's insurance market is consistent with the comparison states and the U.S., where the nationwide trend is that typically 10 companies constitute the vast majority of the total state market. We've also, over the last 5 years, had 21 seller groups that have entered Georgia and 21 that have exited. So bottom line, one company comes in, another comes back. So the claim that they're all going to leave doesn't pass muster. Now let's talk about what's true about our rising premiums. Insurance companies continue to increase premiums on Georgia consumers despite consistently making staggering investment profits off their state-provided market. That's because their main revenue source isn't from us paying our premiums. We allow insurance companies to invest our premium money during what's called the float time. On average, automobile liability insurance claims take 15 months to resolve, while there is a 5 to 10-year lag in long-tail insurance liability lines like medical malpractice. So they invest our premiums in the market, creating essentially 2 pots of money, the premium pot that they use to pay out losses and the investment pot. Georgia insurance companies have earned record profits by investing premiums during this float time. For example, in 2023, although insurance companies nationwide lost $12 billion in underwriting operations, the premium pot, they profited $90 billion in investment income. And in 2024, that industry has profits totaling $144 billion. Despite our rates going up, their shareholders and corporate executives are reaping profits at our expense. So this bill is asking us to abandon the victims, our constituents, that have been wrongfully harmed. Many of them spoke at these hearings, reliving their tragic, traumatic, heart-wrenching experiences to beg and plead that we do not pass this bill. SB 68 will make Georgians less safe and have less access to the courts, but there is nothing that guarantees your insurance rates are going to go down. So I'm pleading with you to vote no on SB 68 and support our constituents. Thank you, Mr. Speaker. I yield the well.
The lady has yielded the well. Representative Maury Crawford is recognized to speak to the bill. Representative Crawford.
Thank you, Mr. Speaker. Friends, today I rise in full opposition of Senate Bill 68, legislation that will be harmful to our most vulnerable constituents and citizens, those who have experienced catastrophic injuries, legislation that was drafted under the narratives that there are too many frivolous lawsuits, there are too many nuclear verdicts, and that litigation increases insurance premiums. First, frivolous lawsuits can already be dismissed under our current rules of civil procedure, and those who bring frivolous lawsuits are sanctioned. Second, nuclear verdicts rarely, if ever, occur. You heard a lot of testimony of proponents saying that nuclear verdicts occur too often and that verdicts don't match the facts. However, what you have not heard is from proponents of this bill explain to you that when an accident occurs, there's an opportunity for defense firms and insurance companies to settle claims within their policy limits. However, they usually prolong litigation, and after prolonging litigation, which substantially harms the injured party, that case is brought to trial, and after jurors hear the egregious facts of a particular case, they return with a verdict that mirrors the facts and evidence. But then even after a verdict is rendered, there's an opportunity for judges to overturn verdicts should the verdict not match the facts in record. So there's really no need for this legislation. Now, proponents of this bill have said that litigation increases insurance premiums, but I have never seen any evidence to substantiate those claims. There's no proof that litigation increases insurance premiums. But when asked if we pass Senate Bill 68, whether or not insurance premiums would decrease, I've never heard a definitive answer. What I've heard is, well, so the question that I have is, why are we attempting to pass legislation for a problem that we cannot prove exists? But then even if we agree that that problem does exist, we are about to pass legislation that will not fix the alleged problem. So I really don't understand the point, again, of this legislation. But there is proof that if we pass this legislation, it's going to interfere with our independent judiciary system. Earlier this session, a former member of this body and the current Chief Judge of our Supreme Court gave his state of the judiciary. And in his address, he said, and I quote it, that Georgia judges must ensure that equal rights are done for the rich and the poor, which promotes the importance of the rule of law and an independent judiciary that helps to build trust and confidence in our courts. Well, unfortunately, to the nearly 1,600 judges in this state that have been elected by our constituents, should this bill pass, it indicates that proponents don't think that the judges know what they're doing. Proponents don't think that the verdicts mirror the facts that are in record. And so there's been a creation of a clause in this legislation that would automatically dictate that certain trials be bifurcated, meaning that attorneys and witnesses would have to testify and present multiple times throughout a trial, which is going to prolong trials and make our courts inefficient. No one wants this. This would be like on crossover day, we having 10 speakers at 11:30 to come and support a bill in this well, prolonging time. No one wants that. No one needs that. It's inefficient. Should we pass this bill with this automatic bifurcation, that's exactly what we will be doing. And ironically, every year, just as soon as I'm standing here, there's going to be legislation where people are proposing to add judges to their judicial circuits, and they're going to cite backlogs in their judicial circuits. Well, I'm here to tell you, if this bill passes, you're going to have to ask for more judges on your circuits because, again, this bill would make our courts system less efficient and create more of a backlogs. But most importantly, this bill is going to harm everyday Georgians, allowing slumlords to go doing whatever they want to. They won't protect some of our most vulnerable citizens. Early in my career, I had an opportunity to represent a young lady who went on a blind date. And after going on a date, she decided to drop the young man off because he didn't have a car. She pulls into an apartment complex, and as soon as she pulls into the parking lot, she's shot at. Yes, she's shot at. Multiple people shot at her car. She got hit in her arm 4 times, and so she has to drive herself to the hospital. And once she gets to the hospital, she learns a few things. First, that hospital is going to have to be her home for the next 4 weeks. Next, she learns that her arm will forever be impaired. She will never have the full range of motion in her arm. So we sent a settlement letter to the insurance company and to the apartment manager, asking that they settle within the policy limits. Of course, they said no. So we continued with litigation. What we learned as we continued to litigate this case is that the on-site property manager was sleeping with gang members within that community. And she allowed gang members to occupy vacant rooms at this apartment complex to grow their criminal enterprise. Tenants told the on-site manager and told the owner of the apartment complex about this incredibly disgusting public nuisance, and nothing was done. And so my former victim was injured because of that. Now that doesn't sound right, but what we learned is that there were so many apartment complexes that had the same criminal patterns. And so, if we pass the bill in the way that it currently is, the young lady who I'm talking about would not have been able to receive full justice. Again, this bill is going to allow terrible slumlords in our state to continue to operate in a way that does not protect some of our constituents and some of our voters. But as opposed to holding slumlords accountable, the first thing that we're going to do is let's just kill all the attorneys. Let's kill all the lawyers because we don't like the litigation. But the problem is that a lot of the people that we represent, their only way through justice is through an attorney that's going to fight for them in court. No one in this room is immune to a catastrophic injury, and I pray that nothing happens to anyone in this room. But should you leave this Capitol and are catastrophically injured, because things happen, then you deserve justice. You deserve full justice and someone who can represent you to make sure that you are made whole after a crazy, catastrophic incident. No constitutional right is more important or fundamental than the right of a trial by a jury. And serving on a jury is the only right that is required in our Constitution and in our country. If we pass this bill, we are significantly endangering that right. I ask that you oppose Senate Bill 68, not because of your side of whether or not you like attorneys or insurance companies, but oppose Senate Bill 68 because the people that we represent can and will be catastrophically injured at some point, and they deserve full justice. Thank you, Mr. Speaker. I yield the well.
The gentleman has yielded the well. Our next speaker is Representative Whip Park is recognized to speak to the bill.
Thank you, Mr. Speaker. Colleagues, a few things. I've had the opportunity to serve in the Rules Subcommittee meetings that heard more than 10 hours of testimony on this piece of legislation. Now, while I am an attorney, I am not a trial attorney. And certainly, as a native Georgian born and raised, I want to ensure that our business community and certainly our hospitals, our medical providers, that we are creating an environment here in the state of Georgia for them to thrive. But this bill is not it. And certainly, we cannot have the most vulnerable among us, injured Georgians who have faced the most egregious crimes inflicted upon them, to bear the burden that this bill would otherwise impose on them. The other thing I've learned along the way is ultimately this is not a bill about big business and trial attorneys. This is a bill about whether or not Georgians and victims have access to justice. Who do trial lawyers represent? Again, they represent everyday Georgians who need help, who need access to justice, which this bill would undermine and otherwise make more different. And so for those reasons, I urge all members of this legislature, of this chamber, to vote no to Senate Bill 68 because it will hurt Georgians, especially our most vulnerable. Now, I want to do everything within our power to lower insurance premiums as well. But again, this bill will not accomplish that objective. We had our Georgia Insurance Commissioner come and testify in committee saying there is no guarantee that insurance rates will go down as a result of this legislation. We have also seen in other states that there is no causal effect with respect to this sort of legislation, this tort reform legislation, and lowering premiums of everyday hard-working Georgians, Florida being an outlier. And so again, as members of this body, we have an obligation to protect the people of Georgia, to ensure that their rights are upheld, their access to justice preserved, and their health care needs met. This bill accomplishes none of those things. SB 68 would weaken protections for victims, make access to health care more difficult, and unfairly benefit big business at the expense of the people we serve. Now again, there was so much brave testimony from sex trafficking victims, from victims of crime, who spoke out against this bill because they understood that this would undermine their ability to recover and seek justice. This bill would provide a shield to criminals and property owners who turn a blind eye to suffering happening on their property. That's not the Georgia I want to live in, and that's certainly not the Georgia we should be building. Now, with respect to health care, Section 7 in particular, the collateral source rule and the amendments and modifications therein, that would devastate access to health care for uninsured and underinsured Georgians who already have a difficult time seeking access to health care. The provision also hurts doctors, patients, and Georgia taxpayers. SB 68 eliminates a crucial financing tool that allows doctors to treat patients who can't afford to pay up front. Without access to those financial tools, doctors will be forced to reduce care, lay off staff, close their properties entirely, or turn away patients. What is the effect of that legislation? It would force the elderly, the poor, the uninsured and underinsured into our emergency rooms. That will further exacerbate all of the healthcare challenges that our state continues to face as a result of the failure and ongoing failure to expand access to health care for all Georgians, which is one of the primary factors that drives everyone's private premiums up. If you have health insurance and your premiums are going up, it's in part because of the failure of this body to ensure that all Georgians have access to health care. This bill undermines the very foundation of our civil justice system. It makes it harder for victims to seek justice and easier for wrongdoers to escape accountability. It weakens the right to a trial by jury, which has been a cornerstone of our democracy for centuries. A jury of our peers is the best safeguard we have to ensure fairness in the legal system, and SB 68 chips away at that principle. So again, I know, especially as we are heading toward the end of this legislative session, our focus may be short-sighted to a certain extent, right? Folks, certainly on the other side of the aisle, and maybe some here and some on the second floor, are positioning themselves to run for higher office, right? Folks may not be here, those pushing this bill may not be here come next year, come 2027. Come 2028, let us think about the long-term consequences of this legislation that will undermine our civil justice system and make it harder for victims to obtain the justice that they deserve. And so, with all that said, again, I urge all of my members on both sides of the aisle to please do the right thing, put Georgians first, especially the most vulnerable among us, and vote no to Senate Bill 68. Thank you, Mr. Speaker. I yield the well.
Thank you, Representative Sam Park. The gentleman has yielded the well. That concludes those speaking that are opposed to the bill. Now those in favor will have up to 30 minutes, and we have one person signed up. That's Representative Chaz Cannon. Representative Chaz Cannon is recognized to speak in favor of the bill, Senate Bill 68. Representative Cannon.
Thank you, Mr. Speaker. Colleagues, like many of you, I've watched the debate on this issue from the sidelines. I've listened and learned a great bit from the many hours of testimony, and I've learned a great bit from those who are deeply involved in this issue on both sides. Some of my very best friends in this chamber are trial lawyers, and some of them are in the insurance business. So there are certainly some personal feelings on this matter for me. And I've given this issue a great deal of thought, more than I expected I would. It's an important topic. I've tried to weigh my friendships on both sides against the best interest of the people in my district and our state. And after consideration of those interests, I rise today in support of Senate Bill 68, a pivotal piece of legislation designed to reform our state's tort system, curtail lawsuit abuse, and foster an environment where small businesses can thrive. This bill addresses the pressing need to balance the scales of justice, ensuring fairness for both plaintiffs and defendants while stimulating economic growth across Georgia. Our current legal landscape has, at times, permitted excessive litigation and disproportionate jury awards, which in turn have driven up insurance premiums and operating costs for businesses, particularly our small enterprises. These escalating expenses often translate into higher prices for consumers and can stifle the entrepreneurial spirit that is the backbone of our state's economy. Senate Bill 68 introduces several critical reforms. By prohibiting attorneys from suggesting arbitrary figures for non-economic damages before all evidence is presented, we prevent undue influence on juries and promote impartial deliberations. Allowing the bifurcation of trials ensures that determinations of liability and assessments of damages are conducted separately, leading to more focused and fair proceedings. Furthermore, by aligning recoverable medical expenses with amounts actually paid or necessary for reasonable care, we eliminate the practice of inflating damages beyond actual costs. This not only ensures just compensation for plaintiffs, but also curbs the inflation of insurance premiums that burden our citizens and businesses alike. The bill also clarifies premises liability standards, requiring that property owners be proven aware of specific security risks they failed to address. This protects businesses from unjust lawsuits while maintaining accountability for genuine negligence. Additionally, permitting evidence of seatbelt usage in motor vehicle cases introduces a common sense approach to assessing contributory negligence, promoting personal responsibility and fairness. By enacting these reforms, we create a more predictable and equitable legal environment. This predictability is crucial for small businesses, which often operate on very narrow margins and are disproportionately affected by the threat of costly litigation. Reducing frivolous lawsuits and exorbitant awards will stabilize insurance costs, enabling these businesses to invest in growth, create jobs, and contribute more robustly to our state's economy. Colleagues, Senate Bill 68 is not just a legal reform. It is an economic imperative. It strikes a necessary balance, protecting the rights of individuals to seek redress while ensuring that our legal system is not exploited to the detriment of honest enterprise and consumer welfare. I urge you all to support this bill. I know it's personal for some folks, but it will foster a fair judicial system and, I believe, a more prosperous Georgia for all. Mr. Speaker, thank you. I yield the will.
Thank you, Representative. Gentleman is yielded the well. That completes those speaking in favor of SB 68 and those that are opposed to SB 68. Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. We'll now move on to our minority report. We have a minority report that will be up to 20 minutes, and we have chair's time that will be up to 20 minutes. We'll begin with our minority report. Representative Evans, are you going to allocate your time? I see you have another speaker as well, so I trust you to take care of that. Representative Stacey Evans is recognized to bring us the minority report.
Thank you, Mr. Speaker, and good afternoon, colleagues. I rise in strong opposition to Senate Bill 68, and I want to talk a little bit, I want to try to address the why that we've heard a little bit about why we need this, and then I want to address the what that this bill actually is. First, the why. We've been told this is about insurance. We've been told this is about insurance companies losing money and they can't stay here, and that's why they're raising premiums, and something's got to be done. I sat through all these hearings, these subcommittee hearings, and some of y'all did too. You know who didn't come in the House? The insurance commissioner. You know who didn't come in the House? Not a single insurance company. Not a single one. Y'all have heard a lot about these cases, CVS and Racetrack. You know who didn't come? CVS, Racetrack. They were there. Their representatives were there. All of them were there. But they never spoke to us. They never let us ask them questions. Why? This is about insurance, but we didn't hear from insurance. Now, I think that I've heard that some of y'all have been told, well, we're going to do insurance reform next year. Let's do this year, and we'll do insurance reform next year. Well, if this is about insurance, why can't we do insurance now? And I want you to also think, ladies and gentlemen, y'all are smart, you're savvy, you've been here before. Remember the last time somebody told you, well, we'll get to that next year. Just remember whether that happened or not. Some of this insurance emergency that we've been told about came out of a report that was done as a result of a bill that we did, the King report. We're relying on that for this alleged situation that we're in. This is from the front page of that report, the contractor who was contracted to do this. The contractor did not independently verify the insurer's data and did not perform any verification procedures to determine the completeness of the data provided by the insurers. Therefore, the contractor makes no representations regarding the accuracy and the integrity of the data and information submitted. And due to the requirements of the bill, this is also in the report, this analysis was completed under a compressed timeline. As a result, the analysis team was unable to correct some data anomalies, which may have identified additional trends. That's what we're relying on here. Incomplete data, not hearing from the insurance company. Now, you've heard about how insurance companies are making money. And let me tell you, ladies and gentlemen, I don't begrudge anybody a profit. I am never going to begrudge them that. And I don't begrudge them coming down here and trying to save more. That's their job. Their job is to try to get more, like your kids. I want more candy. I want more this. I want more that. We sit in the seats of the parents, the lawmakers. It's our job to say no, to balance. And that's what this bill does not do. Now, the fine representative carrying this bill talked a little bit about what it did, but it was a little fast. So I'm going to try to address a little bit. Number 1, Section 1, anchoring. They told you that it's not right for these lawyers to get up there and try to put a dollar value on non-economic damages, and the jury should just decide that on their own. That's their role. Well, let me tell you, ladies and gentlemen, here's what juries do. They make decisions in the enlightened consciousness of a jury. Enlightened means they have to be informed. Advocates advocate on both sides. And we've heard judges say the juries almost always get it right. They know that these are advocates. They can balance that and they make the right decisions. And when they don't, the judges have the ability already under our law to take that away from them. They can take that verdict away. You heard all that Section 2 does is just talk about when discovery begins. That's not all it does, ladies and gentlemen. It ensures, and I can say this without a shadow of a doubt, that good cases will languish. These motions to dismiss, so what's going to happen? This is a little wonky. So when you file a motion to dismiss, right now you get a stay for 90 days. The judge doesn't decide the motion in 90 days. The stay lifts. You can do discovery. You can get evidence. You can find documents. You can ask questions. This says that stay of discovery is going to last forever. Y'all, memories fade, documents disappear. Year after year after year, these cases will languish. I want to talk about Section 6, negligent security. That's probably the biggest change in our law here. I asked corporations in these hearings, these small businesses, you're not asking us to take away liability for everything. No, that is not what we want, but that's what this bill does. This is what this bill says. You could have, under this new Section 6, look at line 224, you got a much higher standard of saying you knew something was going to happen. This reasonable foreseeability is a really high standard now. And even if you meet that, really high standards, if the injury that is complained of is not about exploiting a specific physical condition of the premises, no liability, even if you've met that increased standard. Even if you've met this new threshold. What does that mean? That means no matter how much the owner knows about gang members on the property owner that we heard about that was letting people have rooms, the gang people have rooms, no matter how many times you know there's been knife fights and gang rapes and gunfire, if it's not about a broken lock, a broken window, a security system that failed, an alarm system, no liability, even if you can prove they knew. None. Why would we do that? Now, I appreciate that we have a carve-out in this section for victims of sex trafficking. That's good. But ladies and gentlemen, how do we pick and choose among victims? And the carrier of the bill said, some people are going to tell you that this picks and chooses among people. And he said, well, just read the words on the page. You should read the words on the page. That's exactly what this bill does. Line 275, sex trafficking victims treated differently. Line 279, breaches of contracts treated differently. What about a rape victim? What about a victim of sexual assault in a slum apartment? What about those? How do you look those women in the eye? How do you look their mothers in the eye and say, we are going to treat you differently than a sexual assault victim who was a victim of sex trafficking? How do we do that? Why would we do that? To me, that is the most glaring reason to vote no, ladies and gentlemen. It acknowledges that this standard is too high, and we don't want these victims of sex trafficking left out in the cold. We don't want them to not be able to recover for their damages. Well, why wouldn't we want other victims of crime to be able to recover for their damages? Ask yourselves that, ladies and gentlemen. There's so much to say, but I'm going to close here. You know, anytime I have a big court hearing or a speech or a debate or something, y'all all have your playlist, your pump-up list. I have mine too. Two main songs I listen to. They're very different. Brooks and Dunn, Only in America. And Killer Mike, Never Scared. Why Only in America? Because that's my story, ladies and gentlemen. I don't know if you've listened to that song, but there's a line that says, it's about a bus driver, and she's sitting in traffic, and she's looking in a rearview mirror, looking at the future of our country. And she says, one kid dreams of fame and fortune, and one kid helps pay the rent. That was me, ladies and gentlemen. I remember getting my first paycheck as a salad bar attendant at Shoney's and handing it to my mom, because that's how we stayed where we were. I've never forgotten her, because I've dreamed of fame and fortune, ladies and gentlemen, and I've gotten it. But I will not forget that girl. She doesn't have lobbyists out there. She doesn't have a voice in every courtroom. She has to fight for every single thing she gets. And if she can finally get in there and tell her story, we're going to tell her, nope, sorry. Now, why Never Scared? Because how could I be scared? If I've lived through that, and we've seen victims come down here and plead for us to not do this, to not shut the doors of justice on them. Do you know how hard that must be for them? If they can do that, if they can stand up, it is not hard for me. And I am never scared, and I hope you are never scared too, and I hope you will keep a voice for these victims. And please join me in voting no. Thank you, Mr. Speaker. I yield the majority of the time to Tanya Miller.
The lady has yielded the well. Chairlady Miller is recognized to speak to the bill. Chairlady Miller.
Thank you, Mr. Speaker, and good afternoon, colleagues. Much like my colleague who just left this well, I too grew up the child of a working poor family. And I don't really talk about myself personally. I'm a private person. But I grew up in the mean and cold streets of Cleveland, Ohio, where the sun don't shine, the land of ice and snow. I was raised by a single mother who went to work every single day of her life, barely taking days off, only to be one paycheck away from complete and utter disaster. I watched my mother battle evictions, repossessions, opportunities that passed her by, wishing, as a child always does, that they could protect their mother. There's a reason why I'm telling you this. This was formative for me. It created my why in life. Because what my mother needed in those moments was an advocate, someone who could stand up for her. That became a formative core element of who I am as a person. It charted my course. It sent me to law school, where I fell in love with the law, its consistency, its stability, its sturdiness. It made a child who grew up with instability feel safe, where there was a place that truth mattered. I became a trial lawyer because I fundamentally believed that the courtroom is where everyday citizens, the Davids with only a slingshot, are on equal footing with the Goliaths. I learned that our jury trial system is fundamental to our founding. Y'all know this. We're legislators, we're students of history. We may know that the 12-person jury is a sacred thing, with roots often traced to the Welsh king of Glamorgan, who established jury trials in 725 AD, linking the judge and the jury to Jesus and the 12 disciples. And as such for us, a foundational premise of our union, indeed according to the founders of this great nation of ours, Thomas Jefferson, I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its Constitution. John Adams, representative government and trial by jury are the heart and lungs of liberty. Without them, we have no other fortification against being ridden like horses, fleeced like sheep, worked like cattle, and fed and clothed like the swine and the hounds. James Madison, trial by civil jury in cases is as essential to secure the liberty of the people as any one of the pre-existing rights of humans in nature. I want you to frame this discussion today, my colleagues, understanding what we are tinkering with, understanding that this is not just some bill. This is an attack on the very fundamental premise that makes this country what it is. You disrespect jurors. You accuse them of being confused, hoodwinked, run amok, led astray. Not in a divorce case where they decide which parent gets a child. Not in a contract case between two big corporations where they have to decide complex accounting and whether or not some rule in our jurisprudence has been broken. Not in a murder case where a prosecutor will stand up and ask a jury in this state to send a man to die. Those jurors are okay. But somehow, something happens to the 12 citizens who, by nature of them being in that seat, they are voters. The same people who send you to this seat. Something happens to them when it's a personal injury case, when someone has been killed in a civil case. They get all squirrely. They get confused about the law. They can't decipher whether what a lawyer says is reasonable or unreasonable. They can't apply the law. They don't listen to judges. And by the way, those judges, many of whom appointed by Brian Kemp, we are asked to believe have created a hellhole of a justice system in this great state of Georgia. They are good men and women. They are learned jurists. They do their job under the hardest of circumstances. They don't have enough resources, but they dispense and administer justice every day in state courts and in federal courts from the north to the south of this state. And we come in here and allow them to be disparaged by some DC propaganda PR firm? It's outrageous. This tort reform sham, my brothers and sisters, is a well-run, orchestrated PR campaign. Take the time to research this. Just Google tort reform. Since the 1990s, they've been saying jackpot verdicts, juries out of control. Businesses are closing, doctors fleeing the state. Every time the campaign is run the same way, with the same talking points, the same manufactured crisis. Last year we were fine. We were lamenting the fact that we were the #1 place to do business. But this year, my God, we are crushed and overwhelmed by an emergency in our judicial system. It is a lie. It has been proven to be a lie. It has been debunked over and over and over again. Don't you let them do that to you. This bill is bad for the people. Now let's talk about who this bill hurts, because I think we might go past this a little too quickly in all the jargon and the legalese. And if you can read that bill, my colleague, not as a lawyer, and tell me you understand it, you are probably destined for Mensa. It is one of the most poorly drafted bills I have ever seen as a lawyer, having spent my life interpreting and arguing and trying to understand the law. Now, this bill hurts the 92-year-old elderly woman who died in her bed because she was devoured by fire ants. This bill hurts the 4-year-old baby who went in for a random tonsillectomy. His wound wasn't sutured properly, and by the time he got to the driveway of his home, he bled to death in front of his mother and his brother and his sister. These are the people, the backs upon whom this bill, these lies, are being left. You're gonna tell me it's okay if you're a 12-year-old girl who's been sex trafficked, you can still go to court? Why? Because you have the political favor. You are the political group du jour. But a 12-year-old who just got plain old raped in the stairwell of an apartment complex, who knew they had a dangerous condition and failed to do anything. Well, I'm sorry, my dear. The courthouse doors for you are closed. You want to tell me the father of a child whose family was the victim of a drunk driver who ran to the car his wife was driving, and Mr. Speaker, I'm wrapping up, His wife's legs were broken in the front seat. They'd been hit by an impaired driver. The cars were on fire. He went to get his 6-year-old baby out of the back seat. He picked her up, and he picked up half of her torso. The other half still in the seat because she had misplaced the seatbelt and wriggled out of the shoulder strap, as children often do. That father, you mean to tell me, has to come in and tell you 3 times that he wrangled and held the last of his child split in 2? Why is it that these are the people upon whose backs any of this is being built? I ask you, my brothers and sisters, vote no. My Democrats, I know. My Democrats, I know you are carrying, some of you, the weight of the world on your shoulder. You have been threatened, coerced, tempted, and you don't walk on water.
Ladies' time has expired.
Thank you, Mr. Speaker.
We'll move on to chairman's time now, up to 20 minutes. Chairman of the committee, Chairman Parrish, is recognized to speak to the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I do not intend to take 20 minutes on this. I want to come to a little different approach to this. We're talking about Senate Bill 68. I want to say thank you. I want to say thank you to the governor. I want to say thank you to the Speaker, to the members of this House, the members of the Rules Committee, and especially to our subcommittee on rules that dealt with this. In my time that I've served here in this House, to the best of my knowledge, I can't remember a piece of legislation that had as much attention as this bill does. We sat through over 13 hours of hearing in our subcommittee. We heard from dozens of interested parties that talked to us about what their concerns were, what their interests were, and so forth. Chairman Leverett had the patience to sit there and listen to make sure everyone who wanted to have something to say was heard. And I can tell you that was done. They shared their concerns and they shared their suggestions, and everybody had a chance to state their case. And because of this process, the vetting, changes were made to this legislation. And the changes and suggestions that we heard in our committee meetings were the reason a lot of these changes were made and what they were made for. I believe this bill is a giant step forward in the right direction to do tort reform in this state. I'm going to be voting for it. I'm going to vote yes, and I hope you will join me in voting yes. And Mr. Speaker, I'd like to yield my time to the Chairman Leverett and Whip Burchett.
Thank you, Mr. Chairman. Chairman's yielded his time and recognize. House will now recognize Representative Leverett to speak to the bill. Representative Leverett.
Thank you, Mr. Speaker. Ladies and gentlemen, I urge you to vote for this version of Senate Bill 68. But before I talk about the bill, I want to thank the subcommittee for their service. We did hear a lot of testimony. It was very moving, much of it. It was lengthy. The hearings took a long time. I know you all had other things to do this time of year, and I appreciate your commitment to this endeavor. But I think it was very well worth it. We heard a lot, we learned a lot, we listened. And despite what some have said this morning, we put what we heard in place in this bill. The substitute you're considering today has some meaningful changes. Now, I don't mean to slight the work of our friends across the hall. We had an advantage in that we got to hear the debate over there first and think about it, and then it came to us, so we had more time to deal with it. I don't believe we made any material changes, but we did clarify the intent in ways that I think make the bill clearer and better, and legislation is always good when it's clear. So I'm proud of the work we did, and I'm proud of the hearings we held, and I'm proud of the process we have applied. Now let's talk about the bill briefly. There are 10 sections to the bill. One of them is repealer and one of them is effective dates. You got 8 substantive sections. One of them arguably does make some changes in the type of evidence you can hear that's relevant to prove, and that's the premises section. So it does make some changes. But I would submit to you that while I am sympathetic to any victim out there, I also want to be sympathetic to the people who run the businesses and own the property and are sometimes the defendants. They deserve fairness too. And I think what the bill tries to do is make things fairer for them. For example, the voluntary dismissal. Right now, a plaintiff can dismiss just as the first witness is being sworn. I don't see how you can tell me that is fair to anybody. So we're changing it. We're moving it back to 60 days after the answer is filed. Right now, plaintiffs can talk about non-economic damages. This is things like pain and suffering. Anytime in trial, they can also talk about economic damages anytime in trial. This bill just says, we'll wait until your jury argument to make that argument. Don't do it during the rest of the case. And when you argue, make sure that your argument is rationally related to the evidence. So we're upset now that someone cannot make an irrational argument about how much money they should recover. I don't understand the outrage on that one. And you can still talk about economic damages all the way through the trial that you want to. And you can argue both in your opening and your concluding closing about non-economic damages. So I don't think we're really tipping the scales there, and I would suggest to you that that's a fairer rule than we currently have. We also have the provision on the stay of discovery. That's already the law. There is already a limited stay of discovery. Now, this could result in that stay being longer, but there's already an existing exception in the statute that allows you to get discovery about the issues that the defendant is raising. So you can determine if that motion is valid or not and show that to the court. So while there is a stay, it's not an absolute stay. There are exceptions to it. And that's already the existing law, and that's not being changed. Now, as to the premises section, I think we all, it seems like we're telling much of our state not to believe their lying eyes when it comes to what's going on with respect to insurance rates and with respect to liability. That particular area of the law, I think, has gotten, due to the totality of the circumstances test, it's difficult to plan. It's difficult to know what you need to do, and you're going to be second-guessed if something happens. This simply places some boundaries and some borders on the kind of evidence that can be admitted at trial to prove that claim. It doesn't otherwise change the substantive law, but it does make changes because it does change the evidence that can come in. But I would submit to you that's trying to balance the interest there in a way that's more equitable to everybody and certainly fair to the people who need to know what they need to do. So I would submit to you the whole issue with insurance, I don't know if this will cause rates to change. I don't know if it will cause them to come down. I really don't. If you look at other states, there is a correlation. Despite what's been said here, there have been reductions in rates in Florida. Now, I can't tell you that that's a causal connection there, but I just don't think we can do nothing. I don't think we can sit on our hands and wait. People in our state are telling us they're having serious problems that we need to do something about, and I think based on at least correlations in other states, this will make some difference. Now, I would also say to the extent you're concerned about regulating insurance companies, it's kind of difficult to crack down on them and then have them stay and compete with one another for your premium dollar. And to the extent you're concerned that we're being asked to wait to do insurance reform, we've already done it. House Bill 1114 a year ago has imposed some regulatory reforms on the insurance company so we can check on what they're doing and what they make and what they're earning. So that's already there. I'm all for some additional initiatives, but we have done that already. So I would encourage you to vote for this bill. I think to the extent we worry that we can't do anything, we are putting ourselves in the position of Nero, who fiddled while Rome burned. And we don't want to be in that position. So I would hope you will vote in favor of this bill. And Mr. Speaker, I would yield the remainder of my time to Whip Burchett.
The gentleman is yielded the well. Whip Burchett is recognized to speak to the bill for the final time allotted to the chair.
Thank you, Mr. Speaker. My intent here is to speak to some of the concerns that were raised by my colleagues. And before I do that, let me say I have a great deal of respect for each and every member in this chamber. And the advocates that came to this well have very impassioned statements, but I feel the need to correct the record. First off, there's not one line in this bill, nowhere, that does not allow a rape victim to bring a claim. Not one line in this bill does that. Nowhere. It is disingenuous to say so. And I'll go as far to say that it does not allow a victim of rape can never be made whole, period. Once that line is crossed, a victim of rape cannot be made whole. No dollar amount, no judge, no jury, no advocate, no lawyer can ever make that woman whole. I don't think that it is a genuine statement to come in here and say that a rape victim cannot bring a claim under in this bill. No one in this chamber would support a measure that does that. No one in this chamber would likewise support a measure that decreases access to justice. I mean, there's 50 billboards out there. Call any one of those lawyers. They're going to give you access to justice. I promise. For a small dollar. That's all it's going to take. And I'm a lawyer. And frankly, that is also a disingenuous statement to say that this is closing off access to justice. What this bill does, it is a civil procedure bill mainly, in my mind. Civil procedure. How lawyers act in the courtroom. That's it. The same claims can be brought. Every claim can be brought. One of my colleagues mentioned that this tort form doesn't work. Didn't work in Florida. Simple Google search, February 5th, 2025. Governor Ron DeSantis announces rate reductions for Miami-Dade County, auto insurance reductions statewide, and 11 new companies entering Florida market. May 24th, Florida home insurance premiums falling. May 24th, first downtrend in insurance rate filings in years. Now, it is disingenuous to come in here and say that policy objectives can't affect insurance rates and insurance products. As to my friend's example about the property owner who was sleeping with the gangs, and she knew about the gangs being on the property, I would submit to you that has no place in this bill. That victim could bring a negligent hiring claim, a vicarious liability claim, and a negligent retention claim, none of which are in this bill, none of which are impacted by this bill. So that victim has access to justice. She has the ability to seek out a lawyer and get her day in court. And by the testimony I heard today, I expect that they won or will win. One of the remarks that was made in here was that there was access to health care. Access to health care will be reduced here. I have read this bill. I've reread it. I have had to read it 4 or 5 times because it is a dense bill. There is nothing in here that closes off one emergency room in this state. The hospitals that are supporting this bill, I don't think would be in support of this bill if there was an emergency room closed in this state. And that's our primary access to health care. Everybody in this state of Georgia has access. The doctors have told me a number of times they don't turn away anyone. Access to health care is not impacted by this bill. One of my good friends said that advocates, lawyers, should be able to argue anything in court, specifically saying that they're being constrained of what they can argue in a courtroom. Well, I would submit to you that relating a professional baseball player's salary to how much you want to get for a victim of a car accident has nothing to do at all with that victim's harm. That's all we're saying. Bring rationally relatable measures. Don't talk about a G5, how much a G5 jet costs when you're talking about somebody that's been rear-ended. That's the constraint. I think that's a reasonable constraint. My colleague says we should be able to argue anything. We should be able to argue and say that, the Disney castle costs $100 million, so my client who was rear-ended should get $100 million. That is preposterous. I think that is a stretch, and I think this is a reasonable restraint. Just to say that if you are going to say that my client was hit, my client should be able to recover the cost of their car, the cost of their injuries. We haven't limited that ability at all. Your economic, non-economic damage, special damages, punitive damage have not limited them at all. Limited what you can say as a lawyer, because you're trying to embed these numbers in these juries' head. That's what we're doing here. There was testimony that our courtroom, this bill is going to continue to extend the length of trials. Well, friends, we are past that mark. Anybody that has been in court knows that our dockets are full, and I have a case right now that I've been litigating for 5 years. 5 years. This is not going to push that any further, not one bit further. What it will do, though, is require you to bring a meritorious claim. Bring a claim that's a real claim, because you don't get to tie somebody up with a complaint. Bring a claim and then make your case and then figure out if somebody's liable. You don't bring a meritless case and then drag somebody through discovery for 18 months and then decide, well, we've made them spend $150,000. Now we're just going to voluntarily dismiss. That's happening, folks. One of my farmers in South Georgia had nothing to do with the case. Spent $100,000 answering interrogatories, going to court and trying to tell everybody, I didn't have anything to do with this. Why are you suing me? This is going to make lawyers bring better cases. My colleague said that one of her pump-up musics is Never Scared. I'd be afraid to tell you what mine is. It's pretty out there. But you know who's scared? You know who's scared? Our family businesses are scared. Our family run farms are scared. One of my farmers says, I am scared to put the name of my farm on my daggone truck because somebody's going to run into me. Because they built these businesses, these family-owned businesses, their whole life. It takes one piece of litigation to take everything away from them. Everything. No more house. No more property. No more business. No more way to sustain a living for your children. This does one thing. It changes how lawyers act in the courtroom. That's it. We've litigated this, quite frankly, to death. I'm asking you, I'm imploring you, and I'm begging you, put something up that's going to help us. That's going to move the ball forward in the state of Georgia. This is not going to prevent victims of rape, victims of sexual assault, any victims from bringing any claims. There's nothing in this bill. This doesn't cut off access to civil justice for anyone. Please, please, please support this bill. Thank you, Mr. Speaker. I yield the well.
The gentleman has yielded the well. That completes our presentation and discussion on the bill, both in favor of and those that are opposed. I'm going to ask all members to please come to the chamber. Mr. Clerk, will you ring the bell so we have notice that we're getting ready to vote? Thank you, members, for your attention. Is there any objection to adopting the committee substitute? Hearing none, the committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those who oppose will vote no. And Mr. Clerk, will you unlock the machine? For what purpose is Representative Williams rise? Representative Noel Williams.
Parliamentary inquiry.
State your inquiry.
Is it not true that no person can be turned away for medical care in this state if there is an emergency or bad care in a hospital that accepts Medicare? Is that not true?
I think the gentleman knows what he speaks. His community certainly has a good health system. For what purpose does Representative Hefner rise?
Inquiry, Mr. Speaker.
State your inquiry.
On Monday, September 30th, the leadership of this state converged onto Augusta, Georgia to lend their support for Hurricane Helene victims. Is it not true that for the past 30 days, at least daily, WRDW local news are tracking the following headlines? Homeowners with policies are left feeling uninsured after Hurricane Helene. Are insurers ripping off Georgia victims of Hurricane Helene? And tips on how to navigate insurance appeals for Hurricane Helene victims. Is that not true, sir?
I'm sure you had a long inquiry there.
Thank you, sir.
But I'm sure the lady knows of what she speaks. Have all members voted now? For what purpose does Representative Thomas rise?
Parliamentary inquiry, Mr. Speaker.
State your inquiry.
Is it not true that this bill is focused on curbing lawsuit abuse, making our businesses more, or I guess our economic engine here in the state of Georgia more desirable for investment?
I'm sure the gentleman knows of what he speaks. Now, have all members voted? If so, Mr. Clerk, will you lock the machine? On the passage of Senate Bill 6868, the yeas are 91, the nays are 82. This bill having received the requisite constitutional majority is therefore passed. For what purpose does Representative Burchett rise?
To make a motion.
State your motion.
A motion that we immediately transmit to the Senate.
Representative Burchett moves that Senate Bill 68 be immediately transmitted to the Senate. Is there objection? Gentleman move. There's objection. Gentleman move.
Gentleman move, yes.
Gentleman moves. All right, let's vote it. All those in favor of immediate transmittal will vote yes. Those opposed to immediate transmittal will vote no. Mr. Clerk, will you unlock the machines? Have all members voted? If so, Mr. Clerk, will you lock the machines? On the gentleman's motion, the yeas are to immediately transmit. The yeas are 94, the nays are 77. The bill is passed and it's on the way to the Senate. We'll move on to afternoon orders. But let's do a group of privilege resolutions first. Mr. Clerk, are you ready? We'll hear a group of privilege resolutions. Mr. Clerk, will you read?
Honoring the life and memory of A. Carrion Dwight Perry. Recognizing April 26, 2025 as Mr. Johnny C. Nimes Day. Honoring the esteemed delegation for Wexford, Ireland upon their visit to the Georgia State Capitol. Recognizing and commending the Georgia Association of Senior Centers in honor of National Senior Day. Recognizing and commending Stacia Mack. Recognizing July 9th, 2025 as Level Up Day. Recognizing and commending the Georgia Haitian American Chamber of Commerce. Recognizing March 20th, 2025 as Mapleton Day at the State Capitol. Recognizing and commending the Association of St. Augustine Alumni Atlanta. Congratulating the Cedartown High School cheerleading team for winning the 2024 GHSA Division 4A State Cheerleading Championship. Recognizing the Civil Air Patrol for their service to the citizens of Georgia. Commending and congratulating Clifford Walker Jones, Sr. Recognizing and commending Reverend Dr. William Holmes Robertson on the occasion of his 13th pastoral anniversary. Recognizing and commending Keith Hatcher upon his retirement. Recognizing and commending the women of the State House District 60 during Women's History Month. Recognizing April 22nd, 2025 as DJ Day. Recognizing and commending Reverend Reginald B. Newman on the occasion of his retirement. Recognizing and commending Wesley Nichols. Recognizing and commending Will Anderson Jr. Commending the Good Samaritan Health Centers of Gwinnett. Recognizing and commending Neighborhood Cooperative Ministries. Recognizing and commending Joy Monroe. Commending the National Coalition of 100 Black Women, Inc. and the 100 Black Men of America, Inc. and recognizing March 25th, 2025 as their joint day at this Georgia State Capitol. And for other purposes, that completes the reading of the privilege resolutions.
Is there any objection to the adoption of the privileged resolutions? Hearing none, the resolutions are adopted. Okay, members, we have some members that will come to the well. I need you to give them their attention. They have some important afternoon orders. Representative Schofield, Representative Martinez, and Representative Bonner is recognized for an afternoon order. And other friends as well.
Thank you, Mr. Speaker. Members of the House, we stand today on the cusp of doing some great things here in Georgia. Today, immediately upon adjournment, please join us in room Capitol 132 as we launch the Canadian Caucus, the first state legislative Canadian caucus in the U.S. We are looking to strengthen relationships, foster trade, and explore opportunities in Georgia, between Georgia and Canada. And now I'll yield to some of my colleagues who've been on the front line trying to put this together.
Rachel. Thank you so much, Representative Schofield. Mr. Speaker, thank you so much for having me here. I'm going to tell you a little bit about a great relationship between Georgia and the country of Canada. Canada exported $63.1 million to Georgia in 2023. Gas turbines is the main export. And Georgia exported $26.7 million to Canada, with fertilizers and the fruit juices being their main export. I look forward to a great relationship between Georgia, a great state of Georgia, and Canada, and with our caucus. Thank you.
Thank you, Mr. Speaker.
Hey, good job for our next state. We now yield the,
The lady and the gentleman viewed the well, great partners in commerce with the United States and Canada. Chairman Bonner, now I know you had something you needed to bring to us. The chairman's recognized, and Representative Martinez for an afternoon order.
Thank you, Mr. Speaker. Hey, good afternoon, colleagues. On your desk, I just want to highlight a booklet that was placed on your desk. It's from the Georgia Department of Veterans Services. This highlights all of the benefits the state of Georgia provides to our veteran community. So take this with you, put it in your office, use it as a reference. Commissioner Patricia Ross and her team do an outstanding job at the Department of Veterans Services. And if you have any questions, please come see me. Thank you, Mr. Speaker.
Representative Berry. Take your time. You're fine. Representative Berry is recognized for an afternoon order.
Thank you, Mr. Speaker. Mr. Speaker, I want to take a point of personal privilege today to acknowledge a very special person here with me. My mom is in the gallery with us today.
Gentlemen, to suspend just for a minute. This is special. Y'all pay attention to the gentleman in the well. Continue.
Thank you again, Mr. Speaker. My mom is in the gallery with us today, a very, very, very special guest to us. For good reasons, she's moving to Georgia finally, y'all. I told her she has to vote for me. Like many women across this country and across this state, my mom had issues having me. She almost died having me. And here she is today at 25 years young, and her son is the youngest person elected in the state of Georgia. So we're happy to have her. And I wanted to surprise her as well, because next week is her birthday. Again, she's turning 25 again for like, I don't know how many years this is. So I'm going to have the legislative choir sing happy birthday for her.
Happy birthday to you. Happy birthday to you. Happy birthday, Bryce's mama. Happy birthday to you. You got it down pat.
You're good. Thank you, Mr. Speaker. You're the well.
Representative Berry, after some of those comments, she may spank you when you get home, when she gets you home. I'm not sure. Happy birthday next week. Good to have you here with us in Georgia. Representative Richardson is recognized for an afternoon order. Representative Williams.
Thank you, Mr. Speaker. Actually, I have two. The first one is I'd like to welcome the Columbia County leadership class to the Capitol today. They may still be here, or they may have moved on. They had a tour this afternoon. And the second one is in recognition of Coach Terry Holder. He coached 30 years of high school sports, most in Columbia County. As a head baseball coach, he had 588 career wins, 8 state championships, was 6-time Georgia Coach of the Year, 2-time National Coach of the Year, and in February he was inducted into the Georgia Sports Hall of Fame. So just thank him for coming today. Where's he at? I think he left. He's from Cochran, Georgia. And he's from Cochran, Georgia also. Thank you, Mr. Speaker.
Chairman Stevens, members, if you'll give the gentleman in the well your attention, we're going to be able to complete a very special morning order. We're going to complete this morning order with a recognition. Members, if you'll give the gentleman your attention, please. Chairman Stevens.
Thank you, Mr. Speaker. Earlier, we didn't have the family here when we were doing the recognition for Steve Mitch with the Tyler Perry Studios. So on behalf of Chairman Carpenter, Representative Williams, Representative Gilliard, former Representative Taylor, and the man that started essentially the film industry in the state of Georgia, Representative and Chairman Butch Parrish, wanted to recognize their family if I could. But first, before they stand, we've got a lot of people. I guess they closed down Tyler Perry Studios because a bunch of you guys are here, along with GPP and all of these other folks. If you're with the film industry at all that has brought all of this massive money to the state of Georgia, would you stand so we can recognize you, please? And of course, thank you. And of course, the big thing that we wanted to do today was to honor Steve's family. Dana Lee, would you stand, his wife, and also Charles and twin Adelena, and of course, Josephine. These amazing people, of course, lost their dad and a wonderful husband. Would you please honor them with an applause? Thank you so much for joining us today.
Thank you, members. Mom and children, it's great to have you here. What a wonderful husband and father you did have. And I know he's missed at y'all's home. He's missed by the industry and by friends all over this state and around the country and around the world. Thank you. Representative Sharper is recognized for an afternoon order.
Thank you, Speaker. I'm going to be very, very brief, but the young lady that you guys will see me with today is my wife, Shaquila L. Sharper. We've been together over 30 years, and we'll be actually married 30 years coming up in July. So the lady you'll see me with, that's my wife, all right? Love you. Thank you.
Congratulations. 30 years, that's very special. Members, if you'll help me recognize a former member of this House, Representative Tom Taylor, right here to my left. Let's all make Tom welcome. For what purpose does Representative Hawkins rise?
Make a motion.
State your motion.
I'd like to recommit Senate Bill 140 back to the Health Committee.
Mr. Clerk, will you read the caption?
Senate Bill 140 to be entitled an act to amend Chapter 30, Title 43, the official code of Georgia annotated relating to optometrists so as to provide for doctors of optometry to dispense and sell pharmaceutical agents to patients.
On the gentleman's motion that Senate Bill 140 be recommitted to the Health Committee, is there objection? Hearing none, it is so ordered. For what purpose does Representative Campbell rise?
I make a motion.
State that motion.
I move that House Bill 792 be moved from the Committee on Intergovernmental Coordination to the Committee on Judiciary. Both chairmen are in agreement.
Thank you, Representative. Mr. Clerk, will you read the caption?
House Bill number 792 by Representative Moptown, 17th and others, be entitled an act to amend Article 1 of Chapter 10 and Title 15, the official code of Georgia annotated relating to general provisions relative to magistrate courts, so as to increase the amount of magistrate courts claims from 15,000 to 30,000.
On the gentleman's motion that House Bill 792 be withdrawn from the Intergovernmental Coordination Committee and recommitted to the Judiciary Committee, is the objection. Hearing none, is so ordered. Representative McLean, we're moving on to announcement. Representative McLean is recognized for an announcement.
Thank you, Mr. Speaker.
We have just a few announcements. It may be something you're interested in. Representative Dewey McLean is recognized.
Thank you, Mr. Speaker. A Working Family Caucus lunch will be in room 307, CLOB. Working Family Caucus lunch will be in 307, CLOB. Thank you, Mr. Speaker.
Thank you, Representative. Leader Estration is recognized for an announcement.
Thank you, Mr. Speaker. The committee chairman's lunch will be upon adjournment, room 403 of the Capitol. Upon adjournment, 403, committee chairman.
Chairman Jaspers recognized for an announcement.
Thank you, Mr. Speaker. For those you transportation members who always come up and ask me, how do you get a roundabout, how do you get a road widened, how do you get this bridge repaired, we have the state planning director and her staff will be at transportation today at 2 o'clock in room 606. Look forward to seeing you there. Thank you.
606. I got that part. Chairman Todd Jones recognized for an announcement.
Thank you, Mr. Speaker. The Mental Health and Addictive Disease Caucuses will meet today in CLOB 328 at 2:15. 2:15. Thank you so much.
Representative Tran is recognized for an announcement.
Thank you, Mr. Speaker. Ladies and gentlemen of the chamber, it is Film Day at the Capitol. We've got folks from the film industry in 216. Come say hi to some carpenters, makeup artists, seamstress. And then at 5:30, we're taking it over to City Council or City Hall in Atlanta. So come join us for the latter half of Film Day. Thank you, Mr. Speaker.
Chairlady Camp recognized for an announcement.
Thank you, Mr. Speaker. Intergovernmental Coordination will be meeting today at 3:30 in room 403. Thank you.
Representative Adenia recognized for an announcement.
Thank you, Mr. Speaker. Georgia Legislative Black Caucus members will be having a group photo today at 3 o'clock on the Capitol steps heading towards CLOB. So 3 to 3:30 is going to be a quick photo. Look forward to seeing you there.
That completes our announcements. We have a birthday. Representative Bakaya McQueen. There she is. Happy birthday. We have a group of dedicated pages today, so if you have a page, if you'll meet me down front, we will take some page photos. Majority Leader of this House is recognized for a motion.
Thank you, Mr. Speaker. I move that this House stand adjourned until 9:30 a.m. on Friday, March 21st, 2025.
On the motion of the Majority Leader, this House stands adjourned until 9:30 a.m. Friday, March 21, 2025. All those in favor will say aye. All those opposed say no. The ayes clearly had it. This House is adjourned until 9:30 a.m. in the morning. Thank you, members.